Hello, it's Yoli Medina. So there's a new order out by the judge on the Kohberger case, and it's an order regarding the sealing and/or redacting of documents or filings. And I wanted to cover it because it's kind of interesting. And I thought that this judge was going to be more open, and then he seemed to close things off. And then now it seems like he's scrutinizing the sealing of the documents a little more. But let's take a look at the document that was filed today. Okay, so this is the order regarding sealing or redacting files, and I'm just going to read it. The party's pervasive practice of filing material under seal in this case has become the norm rather than the exception. And I do agree with that. Anyway, rather than seeking to redact discrete sensitive information, entire documents are filed under seal. In addition, much of the material the parties seek to seal is already in the public domain or is simply not confidential or sensitive. And then it has a footnote 1. Let's see. Likewise, the party seeking to seal a document that contains the entirety of the information sought to be sealed in the title of the document is an exercise in futility, because the name of the document, which contains the sensitive information, once filed, is on the publicly available register of actions. Okay, so that was a footnote. Continuing on. This approach runs counter to the public's First Amendment rights to know what is going on in the courts. Consequently, the court will look with scrutiny on requests to seal documents simply because they purportedly contain facts that are not public, but that nonetheless will likely come into evidence. The Idaho Supreme Court adopted ICAR 32 to define when public access to judicial records may be denied, including through the redaction and sealing of court records. To warranting sealing or redaction, the material must meet specific criteria set forth in ICAR 32I, subsection I, so as to allow the court to make the findings necessary to justify its decision to withdraw the material from the public purview. Moving forward, the court will require the parties to adhere closely to this rule and only seek to seal and/or redact material as provided thereunder. In addition, all proposed orders to seal or redact must specify a basis under ICAR 32, subsection I3A, for which the sealing or redaction is warranted. A bare citation to the rule or conclusory summary without an individualized, rigorous factual and legal analysis of the basis for seeking to have documents sealed will result in a rejection of the request. Further, the parties must also seek the least restrictive method to protect information that should be or is exempt from disclosure. For example, despite the court's concerns being expressed previously, the state continues to seek broad orders sealing the entire documents to protect the identity of individuals rather than simply using initials or requesting that a redacted version be made public that discloses only initials. So that's interesting. It's the state that continues to seek broad orders at this point. I know at one point it was both the defense and the state, but right now the judge is talking about the state continuing to seek the broad orders to protect individuals. Okay, accordingly, the state's request to seal filings whole are denied, except as otherwise noted regarding certain exhibits containing grand jury testimony or other exempt records. Rather, those filings have been redacted by the court to refer to certain individuals by initials or family members of the deceased victims by their nature of the relationship, i.e., or example, brother, rather than by name. The original filing will be sealed and the redacted versions will be made public. I guess this is moving forward. It's not going to go backward. So the original filing will be sealed and the redacted versions will be made public. In addition, the court has redacted portions of the defendant's filings that contain grand jury testimony, ordered and dated this 3rd of March, 2025. So that is the judge's order, and I think it's a good thing. Initially I felt that this judge was a good judge. I still feel that way. I know a lot of people were unhappy with his rulings regarding the motions to suppress evidence, but I think it's just the low standard of probable cause that is what caused him not to be able to grant those. I don't do search warrants. I don't know much about the search warrants, but I do know, the arrest warrant, I thought maybe something would come out of that, but it didn't. And all the evidence is coming in. And I think, the defense is going to have a chance to really cross-examine witnesses based on these inconsistencies or things that don't seem right. I know that the work that the police did with their affidavits for the search warrants, it was kind of a mess. It had like headings of Detective Mowry when the body of the affidavit was the affidavit of Brett Payne. And, things like that were clerical mistakes or errors. I mean, that's going to look bad on them if it's allowed to come into trial. So there's a lot more that can be cross-examined now that everything, the judge didn't exclude anything. So we'll have to see what's excluded in a motion in limine, which is a mess right now because I don't even want to look at the case summary, because in that case summary, those documents are listed as filed, but they're not available to the public yet. And I was getting a lot of questions about the autism motion. And I kept thinking, what autism motion? And I was only looking at the documents. And there was one about medical records of the defendant, I believe. But in any event, I'm going to do a video about the other, about that. It's actually a motion to strike the death penalty re-autism or something like that. So I'll do a separate video on that one. But anyway, I just wanted to cover this. And like I said, initially I had the feeling that this judge was going to be more open. And it turns out that maybe he might be. He issued this order where the parties are not going to be able to just cite to those 4 factors that were always misnumbered. It was like 1, 2, 3, 4, 4, 5. It had misnumbering of all basically a restatement of the rule why documents needed to be filed under seal. So anyway, so those are my thoughts, and I'll see you on the next video.